Tell the court, please let the judge know where was it that you were told to go.
We received a run to 16054 Eastwood, I'm sorry, and for a fatal shooting scene.
Did you go there?
Yes, I did.
Describe in general terms what it is at that location.
It's a residential neighborhood. It's a house on a double lot. I believe it faces north. The lot is to the left side or the east side of it.
Did you have an opportunity to go about the premises?
Yes, I did.
During the course of your assignment, I suppose?
That's correct.
And did you notice any parked vehicles in the premises?
Yes, there were several. There were 2 vehicles parked on the front lawn.
What about the back?
And there was also a car parked in the rear yard between the garage and the house.
Did you have an opportunity to observe those vehicles in those circumstances with your own eyes?
Yes, I did.
Inside of the house, Officer Johnson, do you know, are there bedrooms?
Yes, there's 2 bedrooms on the, I believe it was 2 bedrooms on the main floor.
Did you have an opportunity to look at those bedrooms?
Yes, I did.
During the course of your assignment, did you observe anything that was seized as evidence?
Yes, several items.
I'm going to hand you these photographs, if I might, and I've shown these to counsel. Look through those, please, and see if you recognize what it is that I've handed you.
Yes, I recognize these.
You've looked through all of those?
That's correct.
How is it that you recognize what's depicted in those photographs?
Well, these are copies of photographs taken at the scene while we were there.
Do those, the material that's depicted in those photographs, the subjects of what those photographs are, do you recognize them?
Yes.
From being there?
Yes, exactly the way it was on the 3rd of August.
Okay. Judge, I'm going to move to admit them at this point, items 1 through 11, People's Exhibits 1 through 11. Yes.
Now, you're an evidence technician, correct?
That's correct.
All right. So you arrived at the scene after investigators are present, is that correct?
Yes.
And so the scene that you arrived at is not necessarily the scene that when the incident occurred, isn't that correct?
It's a possibility.
That's a possibility?
Yes.
So you weren't there when any incident happened, correct?
That's correct.
And you came after this incident, isn't that correct?
Yes.
All right. How long after the incident did you arrive?
I arrived on this scene approximately 5 p.m. What time the incident happened, I really don't know.
All right. Part of your duty as an evidence technician is to know what time the incident happened?
No.
Okay. So you don't have to know that. Now,
no.
When you arrive at the scene, other police officers are there?
That's correct.
Right. And so you capture the scene after you arrive based on whatever would have transpired prior to you getting there, correct?
I document the scene as it is when I arrive at the scene.
As it is when you arrive at the scene.
That's correct.
Okay. Now those pictures are that you have. Are those pictures of a closet, correct?
There's several photos here. Some of vehicles, yards, closets, drills.
Yeah. Do you remember photographing the closet? For one, do you remember photographing the closet?
I did not photograph the closet, no.
Okay. So those photographs, you didn't take those photos?
That's correct.
So none of those photos you took?
No, I was present with my sergeant, David Babcock, who took the photos, as well as my partner, Christian Kerr, who was at the scene. Us 3 of us worked in unison together.
Okay, so what did you do at the scene?
I noted the location of the evidence, and also directed my partner in items to collect.
So you didn't take any pictures?
No, I did not.
Okay, so those pictures are not pictures that you took?
That's correct.
Okay. And you can't say that the pictures that you took depict the scene at the time that the incident occurred, isn't that correct?
Well, he didn't take the pictures.
I didn't take any pictures.
You can't say that the pictures you directed somebody else to take was the accurate depiction of the scene at the time that the incident occurred, isn't that correct?
I was there when these photographs were taken,
Yeah,
sir.
but you weren't there when the incident happened.
No, I was not.
So you don't know what the scene looked like when the incident happened, isn't that correct?
That's true.
Okay, thank you.
Any objection to the admission of the photographs?
Yes.
What's the objection?
The objection was the photographs may not depict the accuracy of the scene at the time that the incident occurred. And to the extent that it doesn't reflect the accuracy of the scene at the time that the incident occurred, it may be misleading as it regards probable cause.
Well, you have any argument?
No, Judge, I don't know how to respond to that.
You testified that these are the scene as to when he got there, which is about 5 o'clock. Okay, and that's what the court takes it for. So I'm going to, with that in mind, I'll admit it.
Thank you, Judge. Officer Johnson, go through, please, and describe in People's 1 what is depicted. Just in words, describe what that is.
This is the rear yard showing the location of a Chevy Caprice.
And from basically which vantage point would that be?
This would be looking from the driveway in front of the garage, looking in a northwest direction.
Okay. Let's go to number 2, please.
Number 2 is a photograph of the white Caprice in the backyard, showing the driver's side and 2 open doors.
Okay. We're going to keep going on into number 3. And, Your Honor, after they're described for the record, I'd like to publish them to the court if I may.
Number 3 is a photograph of the closet, and this is in the southwest bedroom.
Okay. Number 4.
Number 4 is a close-up photograph of the same closet, showing the live ammunition on the bottom shelf and what appears to be a weapon on the top shelf.
Okay. People's Exhibit number 5, please.
Exhibit 5 is a photograph of an assault-type rifle leaning inside the closet.
That same closet in the southwest bedroom?
That's correct.
Item number 6, or People's Exhibit number 6, please.
Number 6 is just a different angle of the same closet, showing the 2 shelves at the top of the closet.
Okay, let's move on to People's Exhibit number 7, please.
Photograph Exhibit number 7 is a photograph of my partner, Christian Kerr, removing the weapon from the top shelf of the closet.
Were you able to observe that weapon, sir?
Yes, I was.
During any point in time, were you able to document what sort of a weapon that was?
Yes.
Can you tell the court, please, what sort of weapon that was?
It was a High Point brand, .45 caliber.
Do you know, based on your own personal observation and efforts, whether that handgun was loaded at the time that you all were there?
I don't recall, actually. I can't remember if it was loaded or not.
Okay, let's move on to People's number 8 then.
Number 8 is a photograph of my partner holding the weapon, exposing the side of where the serial number is supposed to be.
And you say where the serial number is supposed to be. Is this handgun different than that?
Well, the serial number has been modified. From my experience, the numbers were not legible. They were actually somehow defaced.
Okay. You said that you've been an evidence technician for 11 years?
That's correct.
And a police officer for 18 years?
Yes.
In your experience, have you been trained on firearms?
Not actual firearms training, just from my experience of having to, with different experience from different weapons at scenes for the last 11 years.
Do you have any understanding of whether weapons have serial numbers on them?
Yes.
What is that understanding?
The understanding is that all weapons produced after a certain date, I'm not exact sure on the date, are manufactured with serial numbers so they can be kept track of.
Were serial numbers legible or present on the handgun in question, the high point 45 caliber?
No, they were not.
Based upon your experience and training, do you know why?
It appeared as if they were drilled with a some sort of hand drill or a metal removing device to take the legibility out of the numbers.
All right.
It's speculation.
It is.
They're unreadable.
Correct.
They were. People's number 9.
Oh, People's number 9 is the same photograph, a different angle, showing the what used to be the serial number.
Let's move on. People's 10.
People's 10 is a photograph of the magazine that was removed from the weapon, which does in fact have ammunition in it.
Did that help you to remember whether the handgun was loaded?
Yes, I realize now the magazine was loaded.
Okay. People's number 11.
Photograph in People's 11 is a photograph of Sergeant Hart, a homicide, holding a cordless drill with a drill bit in it that was found in the closet.
The closet of?
Actually, the hallway closet.
Of the same premises?
Correct.
Did you see that drill in its native location there, in the hallway closet?
Yes.
Judge, I'll publish these to the court if you wish to look at them. Okay, thank you, Officer Johnson. Judge, I don't have anything else from Officer Johnson.
You said the drill wasn't in the same closet as the weapons, correct?
That's correct.
It's in a different closet,
Yes.
correct? Okay.
I don't know if you see it. I got a couple questions. Exhibit number 3. All right, can you see that?
Yes.
Okay, where it shows some of this is officers with a phone standing in front of the closet,
That's correct.
correct? All right. And where the weapon is on the second shelf of the closet.
That's correct.
Okay, this is one of your partners?
I believe that was one of the ATF agents that was at the scene.
You know how tall he was?
No, I don't.
The closet door is a standard closet door.
That's correct. I did measure the shelves, sir. I did measure the shelves,
You
if in fact you...
How high they were?
That's correct.
And the second shelf where the gun was located was how high?
82 inches,
Which is
just above the...
7 feet. Correct? Just a little higher than 7 feet.
Yes, just a little bit higher than the top of the door opening.
And the bottom shelf would have been?
49 inches from the ground.
Okay, so that's a little more than 4 feet.
Correct.
Okay. Any questions based on my question?
No, Judge.
Marnie? Do you need him?
Yes, please. May I approach?
Yes, sir.
Showing you what's been marked as Exhibit 3. Now, you indicate that there's in Exhibit 3, what's depicted in there is a weapon at the top shelf. Is that correct?
That's correct.
You say that weapon, that shelf is, you measured 82 inches?
I believe it was 83 inches.
83 inches. From the shelf to the ground.
To the floor, yes.
All right. And then you say this shelf that is depicted with it looks like 3 shells?
3 live rounds.
3 live rounds. 3 live rounds, that was 49 inches?
I'm probably going to correct that. I think it was 69 inches.
69 inches.
That's correct. It was 69 inches.
Okay. And this is number 4. Number 4 is a close-up of the same items that were depicted in 3. Isn't that correct?
That's correct.
So 69 inches and
83.
so 5 feet 9 inches and over 7 feet, correct?
Correct.
But I just suppose for purposes of the record, I think 83 inches is 6'11", just 6'11" inches, just for the purpose of the record. And I certainly would agree with that. I don't have any other questions.
No, you're not.
Thank you, President.
We'll call Officer Patrick Lane. Patrick Lane. Yes, sir. Belly and you.
You swear our affirm to the truth, whole truth, and nothing but the truth, so help you God.
I do.
You have a seat, please?
Sir, for purposes of the record, will you please state your name out loud?
Patrick Lane,
Can you tell the court how it is that you're employed?
Detroit police officer,
How long have you been a Detroit police officer?
approximately 18 years.
Are you now assigned to any particular unit within the Detroit Police Department?
Detroit homicide,
And how long have you been assigned as a Detroit Police homicide officer?
2 years.
What is your rank?
Detective,
Detective Lane, you've been sitting here during the course of today's proceeding, is that true?
yes,
Were you involved in an investigation into the death of Elijah Walker?
I was.
Can you tell the court how it is that you were involved, please?
I was part of a team that made the location after the shooting occurred. I interviewed Mr. Bryson.
When you say you interviewed Mr. Bryson, where did that take place?
At our office,
At whose office?
the public safety office at homicide.
When you interviewed Mr. Bryson, was it the same day that Elijah Walker was killed?
Yes,
When you interviewed Mr. Bryson, was he in custody?
no,
Did you nonetheless provide Mr. Bryson with his constitutional rights?
we did.
How is it that you went about advising Mr. Bryson of his constitutional rights?
We have a form that we have, it's a question-answer form. I'm sorry, it's a statement form where I had him read each bullet point aloud to me.
I'm going to hand you what's been marked on
Before
people's...
you go on, is there, for purpose of preliminary exam only, would there be a stipulation that your client received his constitutional rights, understood them, and made a statement? Just for purposes of exam only.
For exam only.
I just need to know if we've got to go through this whole process regarding constitutional rights.
No. We don't have to go through it. For exam only.
All right, and the court will, based on that,
And whatever objections that I have regarding
the constitutional
constitution
rights.
rights, we'll deal with that at another proceeding.
Okay. All right, the purpose of these hearings, then, the court will find that the defendant received his rights, understood his rights, and made a statement, so we can go straight to the statement.
Thank you, Judge. Did you indeed take a statement from Mr. Bryson?
I did.
And how is that statement memorialized?
In a question-answer format?
Is it handwritten?
Yes,
Who did the writing?
I did.
Did Mr. Bryson sign it?
Yes, he did.
Is it numbered, the pages?
They are.
How many pages?
4.
Let's start at page number 1. There's a section at the top as I'd refer to as biographical information. You see that section?
I do.
And immediately under that, there's a part that says question.
Yes.
Do you understand I'm conducting criminal investigation?
Yes,
Is that how you began the questioning?
it is.
I'd like you to read them then, please. Verbatim question and answer on through pages 1 through 4.
Question. Do you understand I'm conducting a criminal investigation? Answer. Yes. Question. Were you home when Elijah Walker was shot today? Answer. No. I was at work. I was home at around 11 a.m., but I went back to work. Question. Do you own any guns? Answer. Yes. I have a .45 caliber handgun and an AK-47 rifle for about 20 years. I keep the handgun on a shelf in the bedroom closet, in my bedroom closet, with stuff on it, and the rifle is in the same closet against the far wall with my clothes covering it, with the door closed, door locked. Question. Is your room locked? How about the closet? Answer. My closet doesn't have the door handle on it, so it stays locked. My room has a key lock, and I keep it locked. Question. Did you lock your room today? Answer. Yes, when I came home at 11 a.m., I checked it, and it was locked. Question. Are there extras for the lock? Answer. No, I keep the only keys with me. Question. Which room is yours? Answer. When I walk down the hallway past the bathroom, it is on the right. Question. Have you ever caught your son Corey Lucci with a gun? Answer. 2 years ago, my daughter Sierra told me my Corey found my... Let me answer it again. Answer. 2 years ago, my daughter Sierra told my Corey found my .45 and was playing with it. That's why I keep it locked up now. Question. Any other times? Answer. On Friday this past weekend, Corey was shooting a gun in the alley at his mother's house. A neighbor told her about it when she got home at around 4 p.m. Question. Who is Corey's mother? Answer. Kewana Lucci. She lives at 19753 Westphalia. Question. Do you know where he got that gun? Answer. No. I asked Kewana, and she gave it back to her brother's son. I don't remember his name. I don't know where he got it from, but Kewana knew it was her son Julian's. She said he was going to put him out because of it. Question. Did you ask Corey where he got the gun from Friday? Answer. When he was dropped off at my house Saturday, I told him why it was wrong for what he did and disciplined him for it. He said Julian gave it to him, but I know he lied. Question. Does Corey live with you? Answer. No. He and his sister Sierra live with Kewana. Question. Do either of them have a room at your house? Answer. No. I only watch them during the day. Question. Does anyone else live with you? Answer. My mother used to, but she moved. She had the bedroom upstairs. I keep that door locked. My uncle lives with me, Donald Bryson, and he lives in the basement. I also have a friend, Ted Hudson, who has a room next to mine, and I keep that deadbolted. Question. Does anyone else have guns in your home? Answer. No. Question. Were you worried about Corey today? Answer. Yes, because my daughter called me and I asked where Denisha was at. She said she wasn't there. So I kept calling because Corey likes to snoop around. I kept calling to make sure someone kept an eye on him. Him shooting a gun is the worst he has done, and I wanted to watch him. Question. Do you know how Corey brought a gun to your house? Answer. No. I wasn't home when Corey and Sierra were dropped off, Denisha Walker and Sharney Mitchell, my friend, were. Question, how did you find out Elijah was shot? Answer, Corey called me. He said Elijah got shot. I asked him if he did anything. He said, I didn't do anything, over and over again. I called everyone I could think of to go over there and find out because I was at work. I called Denisha, but she was just crying. Question, Corey called you on his phone? Answer, yes, 313-753-2273 at about 1:39 p.m. Question, did I give you an opportunity to look over your statement? Answer, yes. Question, do you want to make any changes? Answer, yes. Only Denisha was home when the kids were dropped off.
And that's the totality of the statement?
Yes.
Did you ever do a survey or look around inside of the home there on Eastwood?
I did not.
Okay. Thank you. I don't have anything else from Detective White.
No question.
Another witness?
Just a moment. Judge, I believe the counsel will join me in stipulating that Elijah Walker was killed by a single gunshot wound to the left side of his head on August 3rd, 2015.
Exam purposes only,
All right, court will accept that stipulation for exam purposes only.
Judge, could I have just one moment, please?
Yes.
Judge, can we approach?
Yeah.
I'll be there.
All right, thank you.
That's all for me.
Happens sometime by today. We're going by tomorrow.
Okay.
Ready? All right, back on the record. 1559851, People State of Michigan versus Curry Dale Bryson.
Your Honor, good afternoon. Michael Woodruff, appearing on behalf of the
John Barney for the defendant, John.
Judge, the court granted us an opportunity, or granted me an opportunity. I asked the court for an adjournment. It was, I had indicated that prior to today, I was under the impression that a tool mark and firearm identification analysis would have been completed, comparing the projectile recovered from the deceased boy with the unfired projectiles recovered from Mr. Bryson's .45 caliber handgun. That analysis is not complete. The court has indicated that, well, I'm not going to characterize the court's position, but it's going to be my position that I do one of two things. One is ask for an adjournment based upon the fact that the requested or the expected report is not available. And if the court denies that request, Judge, what I'm going to do is propose, and I will move at this point to admit into evidence, a recorded statement of the child, Corey Lucci.
What's the basis for entering a recorded statement of Mr. Lucci?
As an offer of proof, Your Honor, I can indicate that the boy provides...
Not what he says. What is the basis under which I can enter it that is not hearsay?
Statement against penal interest.
It has to be a statement against... No. Against who? Mr. Lucci's penal
Against the
interest?
declarant's penal interest.
But he's not a defendant in this case.
I understand that, Judge.
Well, how is it not hearsay?
Well, my understanding that the question of whether it's against penal interest goes to the declarant's penal interest, and that would be the boy, the declarant's penal interest. I have a copy of the rule book right in front of me here.
John, still his thing. Article of statement, not taken on those. And I was being offered for the truth of the matter asserted.
Rule you specifically quote?
Your Honor, it would be Rule 804. B3.
B3 says the statement which was at the time of his making so far contrary to the declarant's pecuniary or propriety interest, or so far tended to subject the declarant to civil or criminal liability, or to render invalid a claim by the declarant against another, that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. A statement tending to expose the declarant to criminal liability and offer to exculpate the accused is not admissible unless collaborating circumstances clearly indicate the trustworthiness of the statement. So if you want me to enter a statement made by an 11-year-old that is against the 11-year-old's interest against this defendant, correct?
Yes, because it inculpates this, not exculpates, it inculpates this defendant.
No. I don't think that's not what the rule says. And no, I'm not going to allow it. So that one's going to have to go up. That issue. Okay. As to the motion for adjournment, the argument. Mr. Barney.
Just for adjournment, huh? Probable cause hearing?
Yeah, we have probable cause hearings in which we go over all this information. I make it very clear that I will not adjourn preliminary exams for any reason. If there's any issues regarding discovery, etc., I tell everybody you have to come back to the court prior to the exam, and then we can discuss what we need to do. But, I don't wait till exam, and I certainly don't wait till we finish whatever testimony we have, and then you know, I understand you just discovered today that you weren't going to have that, but, you know, we're in past the 11th hour, and at this point, we're not adjourned. So, but that motion is denied. Argument.
Judge, what you have before you is evidence that this little boy, an 11-year-old child of the defendant, was known to like guns. He knew that. The defendant, knew that personally. He knew that because 2 years ago, the 11-year-old child had a gun, and he was disciplined for it. He had the defendant's gun, and he was disciplined for it. 2 days before Elijah Walker was shot and killed, this defendant knew Corey Lucci had a gun and was shooting him. So if anyone in the world was on notice, this defendant was on notice that this little boy had an unhealthy fascination with guns. Judge, I think it goes without saying, but I will indicate that guns and children certainly don't mix. I think everyone could agree on that. And in this particular situation, we don't even have to rely on that because Mr. Bryson has indicated that he had called the home a number of times to make sure that people were checking up on his son. Him shooting a gun was the worst he has done, and I wanted to watch him, said Mr. Corey Bryson. So Mr. Bryson knew that there was a present danger in the household that needed watching, and yet Mr. Corey Bryson didn't do the simplest of things that would have secured the weapon and would have prevented this tragedy. Because you can see from the evidence tech photographs that there's a weapon found on the closet, that it is loaded, that it's available, and that but for that weapon being there, Elijah Walker would not be dead. Judge, Mr. Bryson is charged with manslaughter, which requires the prosecution to prove a gross negligence. And in order to do that, we must show that the defendant knew of the danger to another. He knew there was a situation that required him to take ordinary care to avoid injuring another. Judge, I think we've established that by the testimony of Mr. Bryson's own testimony and also by Ms. Kawana Lucci's testimony. The second element is the defendant could have avoided injury by using ordinary care. And, for example, perhaps unloading a weapon would have been an ordinary thing. Using a pistol lock would have been, or a trigger lock would have been an ordinary thing. Or a gun safe would have been ordinary care. None of those things were done. And that flows into the third element, which is that the defendant failed to use ordinary care when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. Judge, not only was that .45 caliber handgun found inside Mr. Bryson's closet, but also the AK-47, which was there was only glancing testimony, but the court can take into account the fact that there's an assault rifle in there that's unsecured and available for children. So any steps that Mr. Bryson may believe he had taken were obviously insufficient. In addition to the manslaughter charge, Your Honor, the defendant is charged with child abuse second degree, which indicates that Mr. Bryson caused serious physical injury, that his actions resulted in serious physical injury to the complainant. Mr. Bryson's also charged with the felony of possession of a weapon with, obliterating the, I don't know the exact language, Judge, it's count down.
He's charged with altering ID marks on the
Yes,
weapon.
yes, Judge. And the statute in that case indicates that there is a presumption that the person who is in possession of the altered weapon is the person who altered the weapon. That presumption has not been overcome in this case, and I think inures to the benefit of the prosecution, because we've shown that Mr. Bryson, not only by the finding of the weapon with the altered serial number in his bedroom, but also by his own statement that was Mr. Bryson's weapon. The presumption flows in the direction of the prosecution in this case. And, Judge, we believe that with all of that, we've satisfied the court by a probable cause basis of the charges filed.
Briefly, in the case of People versus of State of Michigan versus William Patterson, it cites People versus Mendoza, 468, Mich. 527. Involuntary manslaughter is unintentional killing of another without malice through the commission of an unlawful act, not constituting a felony, and not naturally tending to cause great bodily harm, within the commission of some unlawful act, negligently performed. To establish involuntary manslaughter, the prosecution must show that an unlawful act occurred that was committed with an intent to injure or was committed in a grossly negligent manner that approximately caused the victim's death. In these proceedings, it's clear that the shooter who caused the death of the deceased was the 11-year-old. The facts that were elicited today was that the 11-year-old was dropped off at his father's house. The father was not present. He was at work. There was no indication in any testimony that he was even alerted that the kid would be dropped off. Then we had Ms. Mitchell, who testified that there were at least 3 adults always in the presence of those kids, and those 3 adults were the ones who were supposed to be watching the kids. We had the mother testify, and she said she'd never seen Mr. Bryson with a gun. And then we had Mr. Bryson's statement, and in the statement it says that the guns were locked up in a closet, and that the closet had no doorknob on it. Then the court asked the question regarding, I asked the technician, were you there at the time that the incident occurred? So the pictures that were depicting the gun in the closet don't relate to at the time that this event occurred and his son being allegedly in that room. There's insufficient evidence, Your Honor, even for probable cause. There's even no question of fact that would bind this matter over on the principal charges of voluntary manslaughter and the charge of child abuse. The child abuse statute is clear. To cause serious physical injury or serious mental harm to a child by storing or keeping a loaded weapon in a place in his home that was accessible to minor children while having specific knowledge that the 11-year-old with access to the firearm had displayed a fascination with him. So if the 11-year-old is in a room with a locked closet and there's no access to it unless something else occurred, and we don't have any information about what else occurred. That's the only testimony that's in his record as regards that closet and that gun, the statement of the defendant. So for the prosecutor to tell you to take the great leap of faith based on probable cause, Your Honor, there's just no evidence to support manslaughter. There's no evidence to support child abuse. There is some evidence of the technician who's not an expert who says that he couldn't read the serial number on the one firearm. I don't think there's been sufficient evidence for probable cause to bind this matter over on these, and I ask the court to so find and dismiss this matter.
Judge, the interesting thing about that is there is, I was going to say no evidence, but then I was thinking back to the defendant's statement. The only evidence that a closet door or a bedroom door may have been locked, specifically Mr. Bryson's closet or bedroom door may have been locked, comes from Mr. Bryson's own statement. And that evidence is contradicted by the eyewitness, Ms. Charney Mitchell, who said that after Mr. Bryson left, Corey Lucci, the boy, was in and out of that bedroom, lying on the bed. So clearly the door was open. Clearly the 11-year-old had access to that bedroom. And there was no evidence that the door in the closet was locked outside of the statement of the defendant. So, and even if it was locked, a door that could be jimmied by an 11-year-old is no lock at all. So I don't think that there's any evidence that this court can point to or that I can point to to come to that conclusion.
Mr. Mitchell never made
No,
any-
there's no more. You only go, he gets his argument, you get your argument, you get the vote. Stop it there. All right, court having heard the testimony and arguments, finds as follows. Well, as to count 1 and count 2, both of these acts are based on the alleged omission of the defendant. Not any affirmative act that he took, but some affirmative act that he did not take. And I said that because I'm going to come back to that. But that goes directly into count 3, weapons, felony, firearm, where the defendant is charged to carry or have in his possession a firearm at the time he or she committed or attempted to commit felony manslaughter and child degree insanity. It is an impossibility in this court's eyes to charge someone based on their failure to act, an omission, to charge someone with an affirmative act of using a felony firearm. There's nothing on this record that, except the fact that he says he owned the 2 guns. Both guns were in according to his statement. Now, we want to take what the defendant says and pick it apart. Let's do that. He said the room was locked. The room wasn't locked. We know that from the first witness, Ms. Mitchell. And he said the closet door was locked and it had no handle on it. The other thing, that the gun, the handgun, which I assume is the one that the prosecutor is saying was used, that the child used in this shooting. I have nothing on this record to show what gun was used, what kind of gun was used, whether it was a handgun, a long gun, or what. I don't know what kind of gun was actually killed this child. I don't know if it was the gun that was in the closet, either one of those guns. I don't know if it was a gun that was brought from someplace else. There's nothing on this record to show. And without that, I definitely cannot find manslaughter. I definitely cannot find child abuse. And I certainly could not find weapons, felony, and firearm. That in and of itself is enough for the court to dismiss those charges. And that's what I'm going to do. Count 1, 2, and 3 are gone. I will bind over on count 4, which is the weapon, firearm, altering ID mark. There was enough testimony to show that was either attempt or some kind of attempt to scrape off the registration numbers of the handgun that was found in the house, and the defendant admitted that it was in fact his gun. So based on that, there is a presumption that he's the one that took the marks off. The court's going to find that that felony didn't affect current City of Detroit probable cause of discharge as defendant. Found over Wayne County Circuit Court Criminal Division for further proceedings. Arraignment on the information will be September 22nd as to that charge alone.
Your Honor, can I ask for a point of clarification, if I may?
Sure.
Judge, when you were reading off from the information, the predicate felonies under count 3, the felony firearm charge, you read count 1 manslaughter and also count 2 child abuse. Judge, we did charge as a third alternative the altering ID marks on a firearm. And if the court is going to bind over on count 4, I wonder would the court then also bind over on count 3, because that was one of the predicate felonies that was charged.
You want me to charge him with felony firearm based on a handgun that he
Yes.
for all that I know, legally possessed. He just took the presumption that he removed the serial numbers from it. And based on that, charged him with felony firearm. That he intended, because there is a mens rea to felony firearm. There's a criminal intent to that offense that I have to find or be able to infer based on the facts presented. Okay? And based on the facts that I heard today, that there was no mens rea here. There is no criminal or evil intent. There was an omission, allegedly, because everything else is based on his failure to act, his failure, his omission to safeguard, allegedly, these weapons that may have or may not have been used in the shooting that occurred. So, no, I'm not binding over on felony firearm.
Thank you, Joe. That was exactly my point. Thank you.
Okay.
The 22nd, Your Honor, is the AOI.
AOI will be September 22nd.
Thank you, Your Honor. May bond continue?
Bond continue?
I have no objection.
All right, thank you.